Okay. So, very good evening, all the participants. Today we'll discuss some of the important case laws. So, the first case law is innovative industries. So, here, as we were discussing, that the issue of repugnancy came because Maharashtra Relief Undertakings Act is a state legislation and IBC is a central legislation. And as you know, as per the Indian Constitution, there are three lists: list 1, list 2, and list 3. First is union list, second is state list, and third is concurrent list. So, concurrent list where the state as well as the central can legislate. Another point was that the provisions of this code shall override other laws. So, section 238 will prevail. So, Maharashtra Relief Undertakings Act has to give way to IBC. So, this was the case in brief. Now, Mobilox Innovations Private Limited versus Kirusa Software. So, this is a case law which is based on the definition of dispute, what is included in dispute, and section 8 and 9. Here, the case is that these two companies, Mobilox Innovations Private Limited, they got a contract from Star TV for telecasting, televoting of Nach Baliye program on Star TV. And a non-disclosure agreement was signed between these two parties, Mobilox Innovations and Kirusa Software, that they will not disclose this fact to the public. But Kirusa Software disclosed this fact in the public. They said that we are working for Star TV. So when they raised the bill, Mobilox Innovations refused to pay. They said, since there is a breach of non-disclosure agreement, so we will not pay you. This was the issue. Section 9 application was filed after giving a notice. So naturally, Mobilox said that a dispute exists. So reference was made to section 5 subsection 6 also, which says that dispute is an inclusive definition. If we see the Bankruptcy Law Reforms Committee report, then as per the BLRC report, dispute means, but the word means was replaced by the word includes in IBC. So they said that dispute includes what it says, that includes different things. One, there may or may not be an arbitration proceeding. There may or may not be a suit or proceeding. So they said there could be a situation where a dispute exists, although no suit has been filed or no proceeding is pending. So Supreme Court said what is important is the existence of the dispute and or the suit or arbitration proceeding must be pre-existing. So pre-existing here means before the date of receipt of notice. This dispute must exist. That is, must exist before the receipt of the demand notice or invoice. Then they said the word and in section 8(2)(a) has to be read as or. So they said the word and occurring in section 8(2)(a) must be read as or, and later on this was changed to or, keeping in mind the legislative intent and the fact that an anomalous situation would arise if it is not read as or. If read as and, disputes would only start off the bankruptcy process if they are already pending in a suit or arbitration proceedings and not otherwise. So this would lead to great hardship in that a dispute may arise a few days before triggering of the insolvency process. In which case, though a dispute may exist, there is no time to approach either an arbitral tribunal or a court. So what they say, that if there is a plausible contention requiring further investigation, but it should not be a patently feeble legal argument or an assertion of facts unsupported by evidence. So they say that one cannot raise dispute on flimsy grounds, right? So defense is not spurious, mere bluster, plainly frivolous or vexatious. A dispute does truly exist between these two parties, Mobilox and Kirusa, which may or may not ultimately succeed, and the appellate tribunal was wholly incorrect in characterizing the defense as vague got up and motivated to evade liability. So this judgment of the appellate tribunal was reversed. ठीक है? Learned counsel for the respondent, however, argued that the breach of the NDA is a claim for unliquidated damages, which does not become crystallized until legal proceedings are filed, and none have been filed so far. The period of limitation has admittedly not yet elapsed. Further, the appellant has withheld amounts that were due to the respondent under the non-disclosure agreement till the matter is resolved. Admittedly, the matter has never been resolved. Also, the respondent itself has not commenced any legal proceedings after the email dated 30th January 2015, except for the present insolvency application, which was filed almost 2 years after the said email. All these circumstances go to show that it is right to have the matter tried out in the present case before the X falls. We therefore allow the present appeal and set aside the judgment of the appellate tribunal. So, they said that dispute exists and an application under IBC cannot be filed. Third case is State Bank of India versus V. Ramakrishnan and another. Here, this case law is based on section 14. So section 14 says it provides for a moratorium for limited period mentioned in code on admission of an insolvency petition, but it would not apply to a personal guarantor of the CD. So as we know that it doesn't apply to personal guarantor of the CD. So the case here was that the respondent number 1, this Mr. V. Ramakrishnan, he was the managing director of the CD, namely the respondent number 2 company, and also the personal guarantor in respect of credit facilities that had been availed from the appellant SBI. The guarantee agreement was entered into between the appellant and the respondent number 1. Since the company could not pay, the account of respondent number 2 was classified as NPA. Consequently, the appellant issued a notice under Surface C demanding an outstanding amount of 61 crores from the respondents within the statutory period of 60 days. So we have already seen section 13(2) of Surface C Act. As no payment was forthcoming, possession notice under section 13(4) was issued. So as matters stood thus, an application was filed by respondent number 2, the corporate debtor under section 10. So here, the corporate debtor itself filed the application to initiate CIRP, because we know as per section 10, the corporate debtor itself can file the application in case there is a default. And it was admitted, followed by the moratorium that was imposed statutorily by section 14. While the said proceedings were pending, an interim application was filed by respondent number 1 as personal guarantor to the corporate debtor. So here Mr. Ramakrishnan filed an interim application in which respondent number 1 took up the plea that section 14 of the code would apply to personal guarantor as well. So he said that it would apply to personal guarantor as well, as a result of which proceedings against the personal guarantor and his property would have to be stayed. So they said, since moratorium is there and Mr. Ramakrishnan had given a guarantee, so he said that section 14 applies to the guarantor also. So NCLT held that since under section 31, a resolution plan made would bind the personal guarantor as well, and since after the creditor is proceeded against, the guarantor stands in the shoes of the creditor, section 14 would apply in favor of the personal guarantor as well. So NCLT took this ground that it will apply to personal guarantor also. So interim application filed by respondent number 1 was thus allowed, and the appellant was restrained from moving against respondent नंबर 2. ठीक है, ये था. अब आगे चलते हैं. The first important thing that needs to be noticed is that part 3 has not yet been brought in force. Even as of now, part 3 has not been notified. Only the provisions relating to personal guarantors have been notified. This part is entitled Insolvency Resolution and Bankruptcy for Individuals and Partnership Firms. The repealing provisions, namely Section 243, which repeals the Presidency Towns Insolvency Act, and Provincial Insolvency Act has also not been brought into force. Section 249, which amends the RDB Act so that DRT under the Act can exercise the jurisdiction of the adjudicating authority, has also not been brought into force. Under Part 2, which deals with insolvency resolution and liquidation for corporate persons, a financial creditor or a corporate debtor may make an application to initiate this process. Once initiated, the adjudicating authority, after admission of such an application, shall by order declare a moratorium. So, Section 14 refers to four matters that may be prohibited once the moratorium comes into effect. In each of the matters referred to, be it institution or continuation of proceedings, transferring, encumbering, or aligning of assets, action to recover security interest, or recovery of property by an owner which is in possession of the CD, which is conspicuous by its absence, is any mention of the personal guarantor. So, indeed, the corporate debtor and the corporate debtor alone is referred to in this said section. A plain reading of this said section therefore leads to the conclusion that the moratorium referred to in section 14 can have no manner of application to personal guarantors of a corporate debtor. However, section 2E and section 60 are strongly relied upon by the counsel for the respondents, as according to them the code will apply to personal guarantors of corporate debtors. Because if we see section 2E, so section 2E, which applies to the whole of the code because it is contained in part 1. So if they said that if we see section 2E and section 60, which are relied upon by the counsel for the respondents, as according to them the code will apply to personal guarantors of the corporate debtor, and by section 60 proceedings against such personal guarantor will show that such moratorium extends to the guarantors as well. But they held that it doesn't apply to personal guarantors. Pioneer Urban Land Infrastructure Limited versus Union of India. So this is a case which is based on the provisions of section 7 relating to home buyers. So this case challenged the constitutional validity of certain provisions of IBC, particularly after the inclusion of home buyers as financial creditors. Because when IBC came initially, home buyers were included neither in financial creditors nor in operational creditors. But an amendment was brought in to the code and home buyers were awarded the status of financial creditors by way of this second amendment. So section 58F, it was challenged. So that it said that it included the amounts raised from allottees under the real estate projects as financial debt. So this effectively gave home buyers the status of financial creditors, enabling them to initiate insolvency proceedings under section 7. Now, what were the issues before the court? The issues before the court were whether home buyers can be classified as financial creditors, whether this Amendment Act of 2018 it violated Article 14, right to equality, and Article 19(1)(g), freedom to carry on business of the Constitution, and whether the IBC as amended undermined the rights of real estate developers. The amendment was challenged by real estate developers on following grounds. Number one, that the amendment is discriminatory inasmuch as it treats unequals equally and equals unequally, having no intelligible differential. A good management which has several projects on its hand can be removed at the instance of one allottee and either replaced. So the point here is that at that point of time, the amount of default as per section 4 was 1 lakh only. So simply for a default of 1 lakh, they could hold the entire project. So this was the basic grievance of the real estate developers. Okay. So they said management may be good, it may be having several projects, but even at the instance of a single allottee, this whole process could be detrimental to the interest of the real estate developers. So the amendment made in spite of the fact that there is a specific legislation available, namely RERA, which deals in detail with the real estate sector issue and provide for adjudication of disputes between allottees and developers. They said RERA is already there. So, Supreme Court observed that from the introduction of explanation to Section 58F, it is clear that Parliament was aware of RERA and applied some of its definition provisions so that they could apply when the code is to be interpreted. The fact that RERA is in addition to and not in derogation of IBC. It also makes it clear that remedies under RERA to allottees were intended to be additional and not exclusive remedies. So courts also held that even by process of harmonious construction, RERA and the code must be held to coexist, and in the event of a clash, RERA must give way to the code. So Apex Court has upheld this amendment of 2018, which granted the status of financial creditors to home buyers. So the significance of the judgment is that it strengthened the rights of home buyers. It recognized them as important stakeholders in real estate insolvency cases. It upheld the legislative intent, supported the government's move to provide home buyers legal recourse under IBC, and a clarity on RERA versus IBC was provided, and held that both can operate together, each having its own area of operation, each having its own scope. चलिए नेक्स्ट केस था हमारा आर्सलर मित्तल इंडिया प्राइवेट लिमिटेड वर्सेस सतीश कुमार गुप्ता एंड अदर्स. So this case deals with the ineligibility of resolution applicants to submit resolution plans after the introduction of Section 29A. Because Section 29A also came at a later date. Originally, it was not there. And so in the present case, on 2nd of August 2017, that means before this introduction of Section 29A, NCLT Ahmedabad bench passed an order under Section 7 at the behest of financial creditors, being State Bank of India and Standard Chartered Bank, admitting a petition filed under the code for financial debts owed to them by the CD SR Steel India Limited. ठीक है? And sum was 45,000 crores. Satish Kumar Gupta was appointed as IRP and confirmed as such on 4th of September. Now on 24th December, the RP published a request for proposal in which it was stated that the last date for submission of resolution plans would be 29th of January 2018. On a request made by the COC, the duration of the CIRP was extended by 90 days beyond the initial period of 180 days, that is up to 29th of April 2018. The resolution professional issued the first addendum to the request for proposal, extending the date for submission of resolution plans to 12th of February 2018. Now, given this, both ArcelorMittal India Private Limited and New Metal, they submitted their resolution plans. RP found both ArcelorMittal India Private Limited and New Metal to be ineligible. So RP found that both are ineligible. And what was the logic? As far as ArcelorMittal is concerned, the RP found that AM Netherlands BV was declared as a connected person in AMIPL resolution plan. So there was a reference to AM Netherlands BV. And AM Netherlands BV has acquired 29.05% equity in Uttam Galva and has entered into a co-promoter agreement with other promoters of Uttam Galva. And Uttam Galva account was classified as NPA. So 29AC says that if the resolution applicant has an account which is NPA, or there is a company which is under his control, which is having NPA account, then he cannot submit a resolution plan. So this was the logic, that this Uttam Gulwa account was classified as NPA on 31st March 2016 by Canara Bank and PNB. So it was more than 1 year had also elapsed since the account became NPA. So the first thing that was argued at which parties were at loggerheads was the time at which subclause C can be set to operate. So the first point was regarding the timing. According to Sri Rodgi, in the original subclause, pre-amendment time must necessarily be date of CIRP as mentioned by section itself. According to Mr. Salve and Singhvi, it is clear that since submission of resolution plan is spoken of, so it is time of submission of such plan and not any anterior stage. So the first point was, what shall be the date? Whether the date of submission of the resolution plan or date of commencement of CIRP. Okay. The court held that the opening words of section 29A furnish a clue as to the time at which subclause C is to operate. So they said a person shall not be eligible to submit a resolution plan. So it is clear, therefore, that the stage of ineligibility attaches when the resolution plan is submitted by the resolution applicant. The contrary view expressed by Shri Rothgi is obviously incorrect, as the date of commencement of the CIRP is only relevant for the purpose of calculating whether 1 year has elapsed, because this 1 year has to be calculated from the date of classification of the person as NPA. Further, the expression used is has, so which, as Dr. Singhvi has correctly argued, is in present tense. This is to be contrasted with the expression has been, which is used in subclauses D and G, which refer to an anterior point of time. Okay. Another point was that a resolution applicant has no vested right that his resolution plan has to be considered. It is clear that no challenge can be preferred to A at CIRP stage. So RP is not required to take any decision, but merely to ensure that the resolution plans submitted are completed in all respects before they are placed before the CUC, who may or may not approve it. Section 30, subsection 2, subsection E does not empower the RP to decide whether the RP does or does not contravene the provisions of laws. An order was passed under Article 142 of the Constitution stating that one more opportunity be granted to both ArcelorMittal and New Metal to pay off the NPAs of their related corporate debtors within 2 weeks of the Supreme Court judgment. So Article 142 says that the Supreme Court can, in order to render complete justice, so it may invoke the Article 142. So Supreme Court said that let one more opportunity be provided to both to repay their loans within 2 weeks of the Supreme Court judgment, failing which the corporate debtor would go into liquidation. So this was the case. So Article 142, they can ask you a question on Article 142 also. So it grants the Supreme Court the power to pass decrees or make orders necessary for doing complete justice in any case or matter pending before it. This power can be used to secure the attendance of a person, order the discovery or production of documents, or investigate and punish contempt of court. Essentially, it allows the Supreme Court to take action outside the traditional confines of legal proceedings to ensure a just outcome. ठीक. अगला केस है हमारा कमिटी ऑफ क्रेडिटर्स ऑफ एसआर स्टील इंडिया लिमिटेड वर्सेस सतीश कुमार. ये क्या केस था इसमें? So the group appeals and writ petitions raised important questions as to the role of RP, RA, COC. क्या क्या matters इसमें discuss किए गए? What is the role of RP? What is the role of prospective resolution applicant? What is the role of COC? Whether the power of judicial review of the decision of COC by the adjudicating authority and appellate tribunal is limited. Whether equality principle can be applied among secured and unsecured creditors for payment to them under the resolution plan. Treatment should be equitable. Whether committee of creditors can constitute a subcommittee, the answer is yes for administrative purposes. And whether the plan can provide for extinguishment of rights of personal guarantors and whether such a term is binding on them. So it was held yes. So regarding the role of RP. So the court concluded that the RP is a person who is not only to manage the affairs of the corporate debtor as a going concern from the stage of admission till the resolution plan is approved by the A. But he is also a key person who is to appoint and convene meetings of the COC so that they may decide upon resolution plans that are submitted in accordance with the detailed information given to resolution applicants by the resolution professional. Another very important function of the RP is to collect, collate, and finally admit a claim of all creditors, which must then be examined for payment in full or in part or not at all by the resolution applicant and be finally negotiated and decided by the COs. Now, regarding the role of prospective resolution applicant. The court noted that the prospective resolution applicant has a right to receive complete information regarding the CD, debts owed by it, and its activities as a going concern prior to the admission of an application under Section 7, 9, or 10. For this purpose, it has a right to receive information contained in the information memorandum as well as the evaluation matrix. Now, what is the role of COC? So, it is the commercial wisdom of COC that has to decide whether or not to rehabilitate the CD by means of acceptance of a particular resolution plan. So they said that since corporate resolution is ultimately in the hands of majority vote of COC, nothing can be done qua the management of the corporate debtor by the RP, which impacts major decisions to be made in the interregnum between the taking over of management and corporate resolution by the acceptance of a resolution plan by the requisite majority of COC. So what is left to the majority decision of COC is the feasibility and viability of a resolution, which obviously takes into account all aspects of the plan, including the manner of distribution of funds among the various classes of creditors. So what is important is that the commercial wisdom of this majority of creditors, which is to determine through negotiation with the prospective resolution applicant as to how and in what manner the corporate resolution process is to take place. Now regarding the jurisdiction of NCLT and NCLAT. So they said ultimately it is the discretion of the COC that what to pay and how much to pay to each class or subclass. But decision of the COC must reflect the fact that it has taken into account maximizing the value of the assets of the corporate debtor and the fact that it has adequately balanced the interest of all stakeholders, including operational creditors. So this being the case, the judicial review of the adjudicating authority that the resolution plan as approved by the COC has met the requirements referred to in section 30 subsection 2 would include judicial review that is mentioned in section 30 subsection 2 subsection E, as the provisions of the code are also provisions of law for the timing in force. Now, whether equality principle can be applied among secured and unsecured. So court said that treatment may not be equal, but it should be equitable. Another question which was raised was whether committee of creditors can constitute a subcommittee, and it was answered in the affirmative that COC may constitute a subcommittee, but it will be for administrative purposes only, and ultimate responsibility will be of the COC. Another point was whether the plan can provide for extinguishment of rights of personal guarantors and whether such a term is binding on them. So it was also answered in affidavit, and they said that the claims of guarantors stand extinguished. Next case was BK Educational Services Private Limited versus Parag Gupta and Associates. इस केस में क्या था? It addressed the crucial issue of limitation period. ठीक. So the issue here was whether application under section 7 of the code can be filed before A in respect of debt which is barred by Limitation Act. Whether section 5 of the Limitation Act, which talks of condonation of delay, it is applicable to CIRP. And third is whether section 238A as introduced by the Second Amendment Act operates retrospectively. So the decision was that the code cannot be triggered in the year 2017 for a debt which was time barred, say, in 1990. Okay? As that would lead to absurd and extreme consequences. Because when this code came in 2016, impression was that the 3 years limitation period will be counted from now, from December 2016. But it is not so. Okay? So they said the code cannot be triggered by a stale or dead claim, leading to the drastic consequences of instant removal of the present board of directors permanently, and which may ultimately lead to liquidation and therefore corporate death. So this being the case, the expression debt due in the definition section would obviously only refer to debts that are due and payable in law, that is the debts that are not time bound. ठीक है, उन्होंने बोला भाई ड्यू का क्या मतलब है, तो ड्यू का मतलब यही है कि विच इज ड्यू एंड पेएबल इन लॉ, दैट इज द डेट्स विच आर नॉट टाइम बाउंड. जो टाइम बाउंड हो गया वो ड्यू नहीं माना जाएगा. The Supreme Court have held that at least insofar as the code is concerned, the intention of the legislature from the very beginning was to apply the Limitation Act to NCLT and NCLT while deciding applications filed under Section 7 and 9 of the code and appeals therefore. Section 433 of the Companies Act, which applies to the tribunal and appellate tribunal, expressly applies the Limitation Act to the appellate tribunal, the NCLT as well. So, the judgment laid down a clear precedent that IBC proceedings are governed by the Limitation Act, ensuring that only legally enforceable, that is not time-barred debts can be subject of CIRP. And it prevented misuse of the IBC for reviving old or dead claims. Next case is Chitra Sharma and others versus Union of India. तो सुधाकर जी एक बार पढ़ेंगे केस लॉ को, ये इसको, और एनीवन फॉर दैट मैटर, कोई भी पढ़ सकते हैं.
यस सर, मैं पढ़ता हूँ.
आप पढ़िए.
मैं पहले सोच रहा था बिकॉज आपका वॉइस में आई थिंक यू आर वेरी टायर्ड.
हाँ थोड़ा सा, हाँ इसीलिए आई वाज स्पीकिंग अ बिट स्लोली. हाँ
या तो चित्रा शर्मा एंड अदर्स वर्सेस यूनियन ऑफ इंडिया एंड अदर्स. फैक्ट्स. IDBI Bank Limited instituted a petition under Section 7 of the Code 2016 against JIL before the National Company Law Tribunal at its bench at Allahabad. IDBI Bank claimed that JIL had committed a default of Rs 526.11 crores in the repayment of its dues. On 9/8/2017, NCLT initiated the CIRP in respect of JIL. An order of moratorium was issued under Section 14 by which the institution of suits and continuation of pending proceedings, including execution proceedings, was prohibited. An interim resolution professional was appointed under the provisions of the code on 14/2/2017. The IRP called for submissions of claims by creditors, financial creditors in Form C, operational creditors in Form B, workmen and employees in Form E, and other creditors in Form F. On 16/8/2017, the IBVI made an amendment to its regulations, and Regulation 9A was inserted to include claims by other creditors. On 18/8/2017, the board released a press note clarifying that home buyers could fill in Form F as they could not be treated at par with financial and operational creditors. The main grievance for filing the instant petition was the CIRP ignores the interests of vital stakeholders in building projects, chief among whom are individuals who have invested their wealth in pursuit of a human desire to own a home. The IBC in the submission of the petitioners recognized only three categories or classes, namely corporate debtor, financial creditors, and operation creditors. Not being protected by the IBC, the petitioners contended that the rights conferred upon them by special enactments, including the Consumer Protection Act 1986 and by RERA, could not be divested. Suspension of the right to seek redressal before an adjudicatory forum under Section 14(1)(a) would, it was asserted, leave the home buyers without a remedy. Section 238 of the IBC gives it an overriding effect over other laws in existence. Ratio decision. Then the CIRP was initiated, and until the period of 270 days was already concluded, the home buyers did not have the status of financial creditors under the provisions of the IBC. They had no statutory voting rights in the COC. Under the interim direction of this court, a workable arrangement was sought to be put into place by appointing representative of the home buyer into the COC to facilitate their interest being duly borne in mind. But the point to be noted is that in the absence of statutory recognition of the position of the home buyers as financial creditors, the law did not allow for real and substantive entitlement to them in the COC. These statutory entitlements have been brought in by the ordinance in order to recognize the vital interests of the home buyers in a real estate project and to allow them a statutory status in the insolvency resolution process. Unfortunately, by the time that the ordinance came into being on 6/6/2018, the period of 270 days had expired. The resolution plan of Lakshadweep was rejected, and IRP informed NCLT that no resolution plan has been approved within the extended period of 270 days on 12/5/2018. In the present case, a peculiar situation has arisen as a result of which the status of the home buyers, which had not been recognized prior to 6/6/2018, has now been expressly recognized as a result of the amending ordinance. Having regard to the material change which has been brought about by the amendment of the code by the ordinance, and the fact that this court had been in season. What is it, sir? Has been in season of the proceeding. Matlab,
And matlab, it was apprised of the proceedings.
right, sir. Which is a Latin term hoga.
Yeah.
Of the proceedings to ensure that the home buyers are protected. The court was of the view that it is but appropriate and to do complete justice to secure the interest of all concerned that the CIRP should be revived and COC reconstituted as per the amended provisions to include the home buyers. The Supreme Court felt that in the facts of the present case, recourse to the power under Article 142 would be warranted to render complete justice. The power under Article 142 should be utilized at the present stage for the limited purpose of recommencing the resolution process afresh from the stage of appointment of IRP by the order dated 9/8/2017 and resultantly renew the period which has been prescribed for the completion of the resolution process.
So this was the case. So we have to keep the background in mind, that the background of the case is at that point of time, home buyers were not being recognized as financial creditors. That ordinance came later in June 2018. But this petition was filed by Chitra Sharma, and she said that this process, it is ignoring the interest of vital stakeholders in building the projects, because home buyers are the one, and Supreme Court granted them this status. They gave them place in COC, but statutory recognition was not there, so it was not of much consequence. But then they said, in the meantime, this amendment came and they said that let the process start afresh. Although 270 days was already over, so they started the process afresh from the stage of appointment of IRP. And they invoke the powers which are given to the Supreme Court under Article 142. Yes, next case.
Yes, sir. Anuj Jain, IRP for JP Infratech and versus Axis Bank and others. Facts. The IRP preferred an application before the AA seeking orders for avoidance of the impugned transactions whereby several parcels of land were put under mortgage with the lenders of JAL, the holding company of JIL. The contention of IRP that the transactions in question were preferential, undervalued, and fraudulent within the meaning of sections 43, 45, 66 of the code were accepted in part by the AA, the NCLT, in its order dated 16/5/2018, and necessary directions were issued for avoidance of at least 6 of such transactions.
So let me briefly explain this case. So this case is that there are two companies of JP Group. One is JP Infratech Limited, which is having the land bank, and another company is Jayaprakash Associates Limited. These are the two companies. This Jayaprakash Associates Limited is the holding company of JIL. Now JIL was in need of funds, Jayaprakash Associates Limited, but the land was with the JP Infratech. So the land which belonged to JP Infratech was mortgaged to the lenders of Jayaprakash Associates Limited for availing the loan. Now, when JIL went into CIRP, the lenders of JIL said that since we have got mortgage of the land, we should also be included in the COC of JIL. But it was not agreed to, and it was found that these transactions are in the nature of PUFE transactions because they have given preference to the lenders of JL. So this was the case in brief.
Right, sir.
Yes, Yeta. Yes, please. Decision. Decision पढ़ लीजिए please.
Right, sir. Issues नहीं पढ़ना सर.
इशू भी पढ़ लीजिए को इशू मैंने बता ही दिया आपको.
ठीक है सर. ठीक है. The decision based on the fact of the case, court held that mortgage deed in question entered by JIL to secure the debt of the JIL obviously amount to creation of security interest in favor of JIL.
Hmm.
It also noted that JIL was also the operational creditor of JIL and was providing financial, technical, and strategic support to JIL in various ways. It was also noted that assertion made on the behalf of JIL that JIL had pledged 70.83 crore equity shares held in JIL in favor of lenders of JIL had also entered into promoter support agreement to meet the DSRA obligation of JIL towards its lenders and further extended BG, bank guarantee, sir, to
No.
meet the DSRA obligation.
Hmm.
So the court concluded the JIL has given a preference by way of mortgage a preference transaction in question for the benefit of JIL for and on account of antecedent financial debt, operational debt, and other liabilities owed to JIL. The court held that with the transaction in question, JIL has been put in advantageous position vis-a-vis other creditors on the count that A, JIL get a huge working capital, approximately 3,000 crore by way of loan and facilities, extended to it by the respondent lenders. B, by way of transacting in question, JIL liabilities towards its own creditors shall be reduced insofar as the value of the mortgage properties in question, which is said to be approximately 6,000 crores. So obviously, JIL stands clearly benefited and has derived such benefit at the cost of other creditors and stakeholders of JIL.
So the point here is because what section 43 says. Section 43 says that if there is a creation of security interest in favor of the creditor, surety or guarantor on account of an antecedent debt. So here there was an antecedent debt. There were financial liabilities, operational liabilities, and creation of security interest was also there. So they said they have indirectly preferred JAL by creating this security interest in favor of the lenders of JAL. So they said it is a preferential transaction and it needs to be set aside. This was the case, briefly. Yes. Next
Swiss
case.
yes, sir.
Hmm.
Swiss Ribbons Private Limited versus Union of India.
Hmm.
Background. This case involved a constitutional challenge to various provisions of the IBC. The petitioners including Swiss Ribbons Private Limited, challenged the constitutional validity of several key provisions, especially those concerning the role and powers of the resolution professional and the committee of creditors, as well as the differential treatment of operational and financial creditors.
Hmm.
Key issues raised: whether the IBC discriminates between financial and operational creditors under Section 21, validity of Section 12A of IBC, withdrawal application of the admission, role and independence of the resolution professional, alleged excessive delegation of powers to the committee of creditors, overall constitutionality of IBC code.
Hmm.
Supreme Court findings. Differentiation between financial and operational creditors is justified. The court upheld the classification, reasoning that financial creditors are typically involved in assessing the validity of a corporate debtor and are better equipped for the task. The classification was held to be reasonable and not discriminatory under Article 14 of the Constitution. Section 12A is valid, allows for withdrawal of insolvency proceedings with 90% approval from COC. The court emphasized that this provision promotes settlement and resolution, and the high threshold is to prevent misuse. Role of RP is administrative. The RP does not adjudicate dispute but only manages the process. Therefore, the appointment of an RP by the COC was found not to compromise independence. COC's powers are not arbitrary. The court found that commercial relations with the COC are based on the collective wisdom of the creditors and are not subject to judicial review except on limited grounds, example if discriminatory or illegal. IBC is constitutionally valid. The overall scheme of the IBC was found to be fair, non-arbitrary, and within the constitutional framework. The code has a legitimate aim, resolution or liquidation, and is structured to promote economic revival. Conclusion. In the case of Swiss Ribbons Private Limited versus Union of India, the Supreme Court of India confirmed the insolvency and IBC's constitutionality. The court used a broader perspective to defend the court's legitimacy, referring to its useful legislation dealing with economic issues. The court affirmed the concept of judicial hands-off economic legislation, calling the legislation as a successful experiment that had ended the defaulter's paradise. The court might be considered as a rescue operator since it limits the obstacles that a corporate debtor has and makes the settlement procedure go smoothly. True, the best evaluator of corporate debt's validity and viability is the financial creditor. Creditors provide them debt and assist them in making better judgments. The resolution plan in the event of CIRP, unfortunately, a similar circumstance does not exist in the case of an operational creditor. By prioritizing financial creditors, the court has moved a step closer to the court's purpose of restoring the economy to its proper place by facilitating financial debt repayment and the flow of financial resources into the commercial sector. By emphasizing visible differences between operation and financial creditors, the court ensures that the economic legislation's goal is preserved. Its purpose is to increase the pace of debt recovery in the economy.
Yes.
Right. 11. Babulal Vardarji Gurjar versus Veer Gurjar Aluminum Industries Private Limited. Background. This case involved a challenge to the initiation of insolvency proceedings under Section 7 of the IBC by a financial creditor against a corporate debtor, Veer Gurjar Aluminum Industries Private Limited. The appellant Babular Vardarji Gurjar, promoter, suspended director, contested the proceedings primarily on grounds related to the limitation period and the maintainability of the application. Key issues. Whether the Section 7 application filed by the financial creditor was barred by limitation, whether the CIRP could be initiated for debts that had become time barred, applicability of Article 137 of the Limitation Act of IBC proceedings. Facts. The corporate debtor, namely Veer Gurjar Aluminum Industries Private Limited, who was engaged in manufacturing of aluminum and director was Mr. Babula Vardaji Gurjar. Flow of events as below. AA admitted the application under Section 7, being aggrieved by the decision of AA, appellant preferred an appeal before NCLAT. NCLAT held that neither the application under Section 7 is barred by limitation nor the claim of respondent number 2 is so barred and has therefore dismissed the appeal. So, decision. The discussion foregoing leads to the inescapable conclusion that the application made by the respondent number 2 under Section 7 of the Code in the month of 2018, seeking initiation of CIRP in respect of the corporate debtor with specific assertion of the date of default as 8/7/2000 barred by limitation for having been filed much later than the period of 3 years from the date of default as stated in the application. The NCLT having not examined the question of limitation, the NCLT having decided the questions of limitation on entirely irrelevant considerations, and the attempt on the part of the respondents to save the limitation with reference to the principles of acknowledgement having been found unsustainable, the impugned orders deserve to be set aside, and the application filed by the respondent number 2 deserved to be rejected as being barred by limitation. Outcome. The Supreme Court held that the Section 7 application was filed beyond the limitation period without any valid extension through acknowledgement of part or part payment. Hence, it was barred by limitation and liable to be dismissed. Significance. Reinforce the principle that IBC is not a tool for recovery of time-barred debts. Mandated strict adherence to the 3-year limitation period for initiating insolvency proceedings. Directed tribunals to suo motu consider limitation where applicable. Strengthen legal certainty for corporate debtors by disallowing stale claims from triggering insolvency. 12. K. Sasidhar versus IOB. Background. This case arose under the Insolvency and IBC 2016 involving the rejection of a resolution plan by the Committee of Creditors. The core question was whether the NCLT and NALSD can interfere with the commercial wisdom of the COC when it rejects a resolution plan. The resolution plan in question was rejected by the COC even though it met the basic requirements. The promoter K. Sasidhar challenged the rejection, arguing that NCLT, NCLAT should have intervened and approved the plan. Brief facts. Amendment was made in Section 34 with effect from 6 June 2018. According to the amendment, the requisite percentage for approval of resolution plan by COC, which was not less than 75% of COC vote, was reduced to not less than 66%. In case of Kamineni Steel and Power India Limited and Innovative Industries Limited, NCLT rejected the resolution plan and directed for initiation of liquidation process. NCLAT held that in both the cases, the resolution plan did not garner support of not less than 75% of voting share of COC. So the same stood rejected and thereby warranted the initiation of liquidation process. Issues. Whether the percentage of voting share of the financial creditors specified in Section 34 of the Code is mandatory. What is the role of RP in resolution plan? Where the amendment dated 6 June 2018 regarding voting percentage is prospective or retrospective?
So here I would like to add that earlier the percentage for approval of resolution plan was 75%.
5%.
At in this case, when the plan was put to vote, the plan did not garner 75%, but it got more than 66%. In the meantime, this amendment came. So COC said that because it has already got more than 66%, so please don't push it to liquidation. This was the issue. But the court said that the amendment is prospective and it is not retrospective.
Prospective.
Right.
Yes, please.
Right, sir.
Hmm.
According to the RA and stakeholders supporting the concerned resolution plan, the stipulation section 34 as applicable at the relevant time in October 17 is only directory and not mandatory. This argument is founded on the expression may occurring in section 34 of the code. This argument does not comment to us. In that, the word may is ascribable to the discretion of the COC to approve the resolution plan or not approve the same. What is significant is the second part of the said provision, which stipulates the requisite threshold of not less than 75% of voting share of the financial creditors to treat the resolution plan as duly approved by the COC. That stipulation is the quintessence and made mandatory for approval of the resolution plan. Upon receipt of a rejected resolution plan, the AA is not expected to do anything more, but is obliged to initiate liquidation process under section 33(1). SC held that COC is called upon to consider the resolution plan under section 34 after it is vetted and verified by RP as being complied with all the statutory requirements specified under section 32. The RP is not required to express his opinion on the matter within the domain of FCs to approve or reject the resolution plan under section 34. The Amendment Act will have prospective application and apply only to the decision COC taken on or after the date concerning the approval of plan.
So this was the case. Yes, please. Next.
Manish Kumar versus Union of India. Facts. Amendment to Section 7(1) incorporated a proviso that allottees under real estate project financial creditors desirous of triggering the insolvency resolution process under the code are required to file an application jointly by not less than 100 of such allottees under the same real estate project or not less than 10% of the total number of allottees under the same real estate project, whichever is less. Moreover, they should belong to the same project. Further, the petitioners sought to challenge another proviso amending section 7(1) of the code that those applications under section 7 which had not been admitted would stand withdrawn within 30 days. If the newly declared minimum threshold of 100 allottees or 10% of the allottees, whichever is lower, was not garnered by the respective applicants.
So let me tell you the background of this case. The background of the case is the default amount, as you know, initially was 1 lakh only. And home buyers were granted the status of financial creditors. So even if there was a single home buyer who was dissatisfied with the performance of the builder, he could drag the company, he could drag the real estate developer to insolvency. And 12A even was not there. So once CIRP was initiated, there was no going back also. Even withdrawal was not permitted. So naturally, these real estate developers, they were feeling that as if it is against them. So this builder lobby, they approached the government and government brought this amendment that in case of home buyers, a minimum threshold has to be met. A single home buyer cannot be allowed to file the petition for insolvency. So they said at least there should be at least 100 of such allottees on the same real estate project or not less than 10% of the total number of allottees under the same real estate project, whichever is less. Another meaning of this is that even if a single home buyer is having a debt of 1 crore or more, still he will not be able to file the application. So application has to be filed jointly and not singly. Yes, please.
Yes, sir.
And another point was when this amendment came, so The there was a you can say transition clause, and the transition clause was, suppose applications have been filed earlier prior to this amendment. So they said within 30 days either you meet this condition or it shall be treated to be withdrawn. So this point was also challenged, that because when you are bringing this law, so how can you make it retrospective? So that was also the issue in this case. Yes, please.
Yes, sir. 1 minute, sir.
Hmm.
Yeah. Ground taken. The
Hmm.
petitioners have approached Supreme Court under Article 32 of the Constitution of India. The petitioners contended that the second proviso to Section 7(1) of the Code was unreasonable, arbitrary, irrational, ultra vires of the Indian Constitution and violated basic fundamental rights. It was contended that the amendments resulted in hostile discrimination between the petitioners and the other financial creditors, lacking any intelligible differentiation.
Hmm.
However, the SC, in what may be viewed as a blow to allottees of real estate projects, has upheld the provisions amending Section 7(1) of the Code. The SC further clarified that it does not matter whether a person has one or more allotments in the name of his family. All independent allotments would qualify as separate allottees and would be accounted for in the calculation of 100 allottees oblique 1/10 of the allottees. It was then clarified that in case of a joint allotment to more than one person, the allotment is to be treated as a single allotment.
So this was the issue. Next case. Next
Yes,
case is on section 138. Yes, please.
P. Mohan Raj and Shah Brothers Ispat Private Limited.
Hmm.
Facts. Steel products were supplied by the respondent to one Messrs. Diamond Engineering Private Limited, the company, from 21/9/2015 to 11/11/2016, as a result of which Rs 24 crores was due and payable by the company. As many as 51 checks were issued by the company in favor of the respondent towards amount payable for supplies, all of which were returned dishonored for the reason of funds insufficient. My goodness. As a result, on 31/3/2017, the respondent issued a statutory demand notice under Section 138, read with Section 141 of the NI Act 1881, calling upon the company and its three directors, the appellants, number 123 herein, to pay this amount within 15 days of the receipt of the notice. Meanwhile, as the statutory notice under Section 8 of the Insolvency IBC had been issued on 21/3/2017 by the respondent to the company, and as an order dated 6/6/2017 was passed by the adjudicating authority, admitting the application under Section 9 of the IBC. Issues whether the scope of Section 14 of the Insolvency and Bankruptcy Code would cover the magnitude of the NI Act of 1881. It is permitted to initiate. Is it permitted to initiate the check bound proceedings under the NI Act or to continue the proceedings against the CD and its directors when the CD is about to resolve its bankruptcy issue or in an ongoing CIRP? Decision. Section 130 to 141 proceeding against the corporate debtor is covered by Section 14 1A of the IBC. Moratorium provision contained in Section 14 of the IBC would apply only to the corporate debtor. The natural persons mentioned in Section 141 continuing to be statutorily liable under Chapter 17 of the NI Act.
So they said, of course, section 14 bars proceedings against the CD, but it doesn't bar the proceeding against the directors. So they said proceedings can go on against the directors and they can be held liable under Negotiable Instruments Act. This was the case. Yes. I think we can continue up to 10 o'clock if all agree.
Yes, sir. That's fine, sir.
Yes, please. So we'll wind up at 10 o'clock. Yes, please.
Right, sir.
Next.
Yeah. Brief facts. A power purchase agreement entered between GUVNL and Aston Field Solar Gujarat Private Limited, a solar power developer, corporate debtor CD. The PPA was entered on 30th April 2010 in accordance with the
So
GUVNL.
let me tell you in brief about this case. So what was this case? So this case was, you have already read section 14, and section 14 says that whenever there is anything, there is license, permit, quota or concession which if cancelled or terminated may threaten the going concern concept. So they said it is not allowed so long as the current dues are being paid. So in this case, there was a power purchase agreement between Gujarat Urja Vikas Nigam Limited and the other party. ठीक है, Gujarat and Aston Field Solar Gujarat Private Limited. So it said that the Gujarat Urja Vikas Nigam Limited would purchase all the powers generated by the solar power plant of Aston Field Solar Gujarat Private Limited. Now here what happened is that the CD defaulted, and then CD filed an application under section 10 to initiate the CIRP, and it was admitted also. Now Gujarat Urja Vikas Nigam Limited issued notice for default to the corporate debtor, and what was the logic? The logic was that since this company is into CIRP, so it amounts to an event of default under power purchase agreement. Default notice specifically stated that the power purchase agreement will be terminated if the corporate debtor does not cure the defaults mentioned in the default notice. So this termination notice, so they said that okay, we will terminate the power purchase agreement. And what was the logic given by them? The logic given by them was that since you have filed an application under section 10, that means there is a default. So we are cancelling the power purchase agreement. So this was the issue. So this termination notice was stayed by NCLT. NCLT held that the clauses of the power purchase agreement cannot be placed on a higher pedestal than the provisions of IBC. Power purchase agreement is an instrument with the meaning of section 238, and in the present case the clauses of the power purchase agreement are inconsistent with the provisions of IBC. So NCLT also held that this Gujarat Urja Vikas Nigam Limited attempted to terminate the power purchase agreement on the sole ground that the CIRP has been initiated against the CD. So it was observed that during the CIRP, the RP has to maintain the corporate debt as a going concern, and termination of the power purchase agreement would render the corporate debt a defect. अगर power purchase agreement ही नहीं रहेगा तो इसको खरीदेगा कौन कंपनी को, ये इशू था इसमें. Yes, please.
Yes, sir. So the apex court observed that the IBC contemplated the establishment of a single forum in order to deal with the matters of insolvency, which were distributed earlier across multiple fora. The apex court, placing reliance on ArcelorMittal India Private Limited versus Satish Kumar Gupta, observed that the NCLT alone has jurisdiction when it comes to applications and proceedings by or against a corporate debtor covered by the code, and no other forum has jurisdiction to entertain or dispose of such applications or proceedings which arise solely from or which relate to the insolvency of the corporate debtor. In the instant matter, PPA was threatened to be terminated solely on the ground of insolvency. In the absence of the insolvency of the corporate debtor, there is no other ground to terminate the PPA. The Honorable Court recognized that Section 86(1)(f) of the Electricity Act empowers GERC to adjudicate dispute between generating company and the distribution licensee. However, NCLT will have the power to adjudicate the present dispute under Section 65C of the IBC because the sole default attributed by GUVNL to the corporate debtor was that it was undergoing an insolvency resolution process. The Honorable Court further held that Section 238 of the IBC stipulates that IBC would override other laws, including an instrument having effect by virtue of any such law. The NCLT correctly stated the termination of the PPA by the appellant, since allowing it to terminate the PPA would certainly result in the corporate death of the corporate debtor due to the PPA being its sole contract.
So this was the case.
Yeah.
Yes, please. Next.
Right, sir. 16.
So next case is, if I tell you in 2 lines, what is this Arun Kumar Jagaratmaka case? The case is that suppose there is a resolution applicant which is ineligible under 29A. So whether he can be a party to an application under section 232, 232 of the Companies Act, and section 232, 232, you know, deals with compromise arrangement and amalgamation. So they said whether a person who is ineligible under 29A can be in any way a party to this compromise arrangement and amalgamation, and the Supreme Court said no. Yes, please.
Right, sir. The judgment was rendered in an appeal filed by Jindal Steel and Power Limited, an unsecured creditor of the corporate debtor, Gujarat NRE Coke Limited. The appeal was preferred against an order passed by the NCLT in an application under Section 230 to 232 of the Companies Act of 2013, preferred by Mr. Arun Kumar Jagatramka, who is a promoter of GNCL. National NCLT held that a person who is ineligible under Section 29A of the IBC to submit a resolution plan is also barred from proposing a scheme of compromise and arrangement under Section 230 of the Companies Act 2013. Honorable Supreme Court in Swiss Ribbons Private Limited and another versus Union of India and other writ petitions, so and so held that the primary focus of the legislation is to ensure revival and continuation of the corporate debtor by protecting the corporate debtor from its own management and from a corporate death by liquidation. Issue: whether in a liquidation proceeding under IBC, the scheme for compromise and arrangement can be made in terms of Section 230 to 232 of the Companies Act. If so permissible, whether the promoter is eligible to file application for compromise and arrangement while he is ineligible under Section 29A of the IBC to submit a resolution plan decision. Yes, as per the provisions under within 90 days. Prohibition placed by the Parliament in Section 29A and proviso to Section 35(1)(f) of the IBC must also attach itself to a scheme of compromise or arrangement under Section 230 of the Companies Act of 2013 when the company is undergoing liquidation under the auspices of the IBC.
So this was the decision. Next case.
Right, sir. Lakshmi Pat Surana versus Union Bank of India. Background. The case concerns whether proceedings under Section 7 of the Insolvency and Bankruptcy Code IBC 2016 can be initiated against a guarantor, not the principal borrower, especially when the principal borrower is not a corporate person but the guarantor is. In this case, UBI filed an application under Section 7 against Lakshmi Pat Surana, corporate guarantor, for the loan granted to Mahavir Construction, a sole proprietorship non-corporate entity. Key legal issues: can a financial creditor initiate insolvency proceedings against a corporate guarantor under Section 7 of the IBC if the principal borrower is not a corporate person? From when is the limitation period to be calculated for initiating proceedings under IBC in such cases? Facts: a bank extended the credit facility to Messrs. Mahavir Construction, a proprietary firm of the appellant, through two loan agreements in the year 2007 and 8 for a term loan of 9.60 crores and a further amount of 2.45 crores respectively. The loan amount was disbursed to the principal borrower. Messrs. Surana Metals Limited has offered guarantee to the two loan accounts of the principal borrower. The stated loan accounts were declared NPA on 31/2010. The financial creditor then filed an application under Section 19 of the Recovery of Debts to Banks and Financial Institutions Act 1993 against the principal borrower before the Debt Recovery Tribunal at Kolkata. This application came to be resisted on diverse counts and specifically on the preliminary ground that it absolutely was not maintainable because the principal borrower wasn't a corporate person. Further, it has been barred by limitation because the date of default was 30/1/2010, whereas the application has been filed on 13/2/2019 beyond a period of 3 years. Significance: this judgment clarified that corporate guarantors are independently liable under IBC even if the principal borrower is not a company. FCs have the right to initiate CIRP against guarantors without first proceeding against the principal borrower. Strengthen creditors' hands in enforcing guarantees through insolvency. Reinforce the doctrine of coextensive liability of guarantors. Yeah, ये भी पढ़ो sir.
आप पढ़ लीजिए.
Ghanshyam Mishra and Sons Private Limited through authorized signatory versus Edelweiss Asset Reconstruction Company Limited. Background: this case clarified the finality and binding nature of an approved resolution plan under the Insolvency and Bankruptcy Code 2016. It focused particularly on the effect of Section 31(1) of the IBC and the 2019 amendment that added an explanation to it. The dispute arose because some creditors attempted to pursue claims against the corporate debtor even after the resolution plan was approved, arguing that their dues were still recoverable.
So let me briefly explain this case. Actually, government departments, when this IBC came, so they were under the impression that although resolution plan is approved, but still they can recover their dues. Suppose they got 40% of their dues because 60% was the haircut. And suppose there is a government department, say VAT department or income tax department, against the demand of 100 crores, suppose 40 crores is given to them. So now what they will do? They will issue another notice in the name of the CD after the approval of the resolution plan that 60 crores is due. 40 we have got, 100 was the demand, now 60 is due. And then thereafter this amendment, this clarification came that all claims stand extinguished, including government departments. So this line, including government department, was specifically written to, in order to clarify this issue, that the approved resolution plan is equally binding to them also. They are not above this IBC. इनकम टैक्स डिपार्टमेंट, वैट डिपार्टमेंट, एक्साइज डिपार्टमेंट, ये क्या करते थे, बाद में दूसरी कंपनी के अगेंस्ट में, जो नई कंपनी, जो नया मैनेजमेंट है, उसको नोटिस दे रहे थे कि भैया आधा मिल गया, अभी हमारा पैसा बाकी है. तो ये केस गया सुप्रीम कोर्ट. यस प्लीज.
Right, sir. Key issues. Are all claims, including statutory dues, extinguished once a resolution plan is approved under Section 31(1) of the IBC? Can any creditor, including government department, continue to pursue claims not part of the resolution plan? The Supreme Court held that no creditor, including government authorities, can initiate or continue proceedings for claims not part of the approved resolution plan. All such claims stand extinguished once the plan is approved. In Ghanshyam Subra and other similar matters, various tax authorities and government departments pressed their claims against the CD even after the resolution plan was approved by the adjudicating authority. A major issue was raised in relation to the claims that did not form part of the resolution plan. It was argued that such claims be permitted to be enforced even after the resolution plan was approved. In the matter of one of the connected matters, Edelweiss Asset Reconstruction Company versus Orissa Manganese Minerals, the Honorable NCLAT, while dismissing the appeal, left it open for these creditors to press their claims before a civil suit or appropriate forum. The Honorable SC has set aside the NCLAT's findings and reiterated the law laid down in COC of SR Steel India Limited through authorized signatory versus Satish Kumar Gupta and others, wherein the SC categorically held that once the resolution plan is approved, all claims stand extinguished and the CD is handed over to the resolution applicant RA as a fresh slate. Significance. This ruling gives certainty and finality to resolution plans, encourages the resolution applicants by protecting them from past liabilities, strengthens the clean state doctrine, which is critical to effective corporate rescue, clarifies that statutory dues are not immune from discharge under IBC.
So I think we can stop here. है ना?
Right. Yes, sir.
So we can stop here and we can continue the discussion. We will write in the group के